he would go to work. This was an extraordinarily rare routine.
So, Jamie, we're talking about here a variation in routine. Something that I found interesting was attached to the brief for the government is Exhibit A. And Exhibit A is making all the objections to the doctor's PowerPoint that was produced as part of discovery in the case. Things that they're saying, well, he never provided us a study. He never showed us the article about people in the airplane crash, about people forgetting guns in the bathroom. We can't cross-examine those people. And then stunningly to me, they emphasize in bold that Harris's statement, the defendant's statement that he gave to Dr. Diamond would be hearsay and therefore should be excluded. Now, look, I know that state laws can differ from place to place, but they're generally the same. Can you please talk to us the difference about hearsay as opposed to the information experts are allowed to rely upon and with a limiting instruction by the court if need be with respect to hearsay not being substantive evidence, but it goes to the credibility of the opinion of the expert. And of course, the other side, if they don't like it, has a thing called cross-examination to attack that witness.
Yeah, Bob, that's a really important distinction. You know, hearsay generally is not allowed. We have certain exceptions. Even when it comes to lay people, certain hearsay can come in. When it comes to expert testimony, hearsay is generally allowed if it's utilized in the context of them forming their opinions for the purpose of the court. There are exceptions to that as well. The opinion can't be based entirely on hearsay. But when there's other evidence that is not hearsay, hearsay is then allowed. So, you know, this objection it should fall on deaf ears. This was the defendant. This was the client. His opinions are based around the behavior of the client. So anything that Mr. Harris told him during the course of preparation of his testimony should be admissible for the purposes of what we're talking about here today. And as you've indicated, you know, the court has broad discretion when it comes to what they're going to allow and when it comes to expert testimony. You know, I've seen cases where the person had never been qualified before, right? Everybody has to be qualified for the first time first. And those are tough to swallow. Here, I believe he was qualified 13 times, 10 in a criminal context, 3 in a civil, if I recall. And, you know, this judge would have a lot of discretion as far as what she wanted to allow in, but she also would have the tool in her belt that the prosecutor could ask for, and that would be to instruct the jury as to how much weight they should give any one particular piece of testimony. And in this case, let's just presume that for the sake of the hypothetical that the defendant was never going to testify, you know, I think it would be appropriate under those circumstances to give a very limited instruction that while defendants have an absolute right not to testify, in the context of what you heard from Dr. Diamond's testimony, you could maybe discredit some of that information or not take it as you would as if the prosecutor would have had a chance to ask questions himself.
Right.
Himself.
So we are, guys, I think, in an agreement in a very nuanced area of the law that experts are allowed to rely upon hearsay. We should probably let you know that that's an out-of-court statement used to prove the truth of a matter, as opposed to an expert who can rely on hearsay, like doctors can rely on X-rays and various reports and statements of a witness. It happens all the time, or of a client. It happens all the time. But they give a limiting instruction saying that's only with respect to whether you value the credibility of the psychologist or the expert's testimony, and you can use it for that purpose. You just don't outright exclude it. Thanks, guys. Awesome as